If you are waiting for a green card, whether employment-based or family-based, what the State Department just released could change your entire timeline. The April 2026 Visa Bulletin dropped yesterday, and I need you to stop everything you are doing right now and pay attention because this is not a minor adjustment. This is not a small technical update. This bulletin contains some of the most significant movement we have seen in years across multiple categories, and depending on your priority date and your country of chargeability, you may suddenly be current or very close to filing your I-485 adjustment of status application. But here is the critical part. If you do not understand how to read this bulletin correctly, if you do not know which chart applies to you, you could miss your window entirely. And that is exactly why I am breaking this down for you today, line by line, category by category. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. No fear-mongering, no rumors, no speculation presented as fact, just straight policy analysis delivered calmly and accurately so you can make informed decisions about your immigration future. Before we go any further, I need to be very clear with you. I am not your attorney, and this content is for educational and informational purposes only. Immigration law is incredibly nuanced and case-specific. Always consult with a licensed immigration attorney about your specific situation before making any decisions or filing any applications. With that said, let us get into exactly what the April 2026 Visa Bulletin tells us and what it means for you. The U.S. Department of State releases the Visa Bulletin every month, and it controls when immigrant visa applicants can either apply for an immigrant visa at a U.S. consulate abroad or file their I-485 adjustment of status application if they are already inside the United States. The April 2026 Bulletin, which becomes effective on April 1, 2026, contains movement across both employment-based and family-based categories that I think will surprise a lot of people who have been waiting for years and had almost given up hope. Let me walk you through the most important changes. Starting with the employment-based categories. The EB2 category for India has moved forward by approximately 14 weeks on the final action dates chart. Now, I know 14 weeks does not sound dramatic when you have been waiting for potentially a decade or more, but in the context of EB2 India, which has historically moved at a glacial pace or even retrogressed, this is significant sustained forward progress. The new final action date for EB2 India is now January 15, 2014. If your priority date is on or before that date, you are now eligible for final adjudication of your green card. This movement follows 3 consecutive months of forward progression, which suggests the State Department is seeing actual visa number availability that is allowing them to push these dates forward with some consistency. But here is where this becomes critical. The EB3 category for India has moved even more aggressively. We are looking at approximately 19 weeks of forward movement, bringing the final action date to March 1, 2013. Now, some of you watching this are going to immediately ask, wait, EB3 is further behind than EB2, why would I downgrade? And that is exactly the kind of strategic analysis you need to be having with your immigration attorney because depending on your specific priority date, your employer situation, and your long-term timeline, there may or may not be advantages to considering category changes. I am not telling you what to do. I am telling you these are the questions you need to be asking qualified legal counsel. For applicants chargeable to mainland China, we are also seeing meaningful movement. EB2 China has advanced by approximately 11 weeks. EB3 China has moved forward by about 8 weeks. The final action dates for China are now positioned such that applicants with priority dates from mid-2020 and earlier in some categories may now be approaching current status or becoming current in the coming months if this trend continues. Now, the EB1 category, which covers priority workers including individuals with extraordinary ability, outstanding professors and researchers, and multinational managers and executives, remains current for all countries except India and China. For India, EB1 has moved forward by approximately 6 weeks. For China, EB1 has moved forward by about 4 weeks. This is important because EB1 was severely backlogged during certain periods, and any forward movement in this category represents opportunities for highly credentialed applicants who have been stuck in administrative limbo. This is what many green card applicants are misunderstanding. When we see this kind of sustained movement across multiple employment-based categories, it often indicates that the State Department is working through a backlog more efficiently, or that demand in certain categories has decreased relative to supply, or that there is a specific policy-driven effort to reduce wait times. What it does not mean is that this movement is guaranteed to continue indefinitely at this pace. Visa Bulletin movement is notoriously unpredictable. We have seen months of forward progress followed by sudden retrogression. So while this news is positive, it is not a guarantee of your future timeline. Let us move to the family-based categories because there is substantial movement here as well that affects millions of applicants worldwide. The F2A category, which covers spouses and unmarried children under 21 of lawful permanent residence, remains current for all countries on both the final action dates and the dates for filing charts. This is excellent news for LPRs who have petitioned for their immediate family members. If you filed an I-130 for your spouse and you are a green card holder, not a U.S. citizen, your spouse may be able to proceed with their immigrant visa or adjustment of status application without waiting for priority date advancement. The F2B category, covering unmarried sons and daughters 21 and older of lawful permanent residence, has seen movement of approximately 10 weeks for Mexico and the Philippines. These two countries have historically had some of the longest backlogs in family-based immigration, and any forward movement is meaningful for families who have been separated for years, sometimes decades, waiting for visa availability. The F3 category for married sons and daughters of U.S. citizens has moved forward by approximately 6 to 8 weeks for most countries, with Mexico and the Philippines seeing slightly more modest movement. The F4 category for brothers and sisters of adult U.S. citizens continues to have extremely long wait times, but even here we are seeing forward movement of approximately 5 weeks across most countries. There is one detail most people are missing. The April 2026 bulletin also indicates that USCIS has confirmed they will accept I-485 applications based on the dates for filing chart for both employment-based and family-based categories for the month of April. This is not automatic every month. USCIS makes this determination monthly based on their processing capacity and workload. When they authorize the use of the dates for filing chart, it allows applicants whose priority dates are current under the dates for filing chart but not yet current under the final action dates chart to file their adjustment of status applications. This means they can get their applications into the system, obtain work authorization through an employment authorization document, obtain advanced parole for international travel, and begin the final phase of their green card journey even before a visa number is immediately available for final adjudication. You can verify this directly on the USCIS website. They publish a page titled Adjustment of Status Filing Charts from the Visa Bulletin, and it confirms each month which chart applies. For April 2026, both employment-based and family-based applicants should reference the dates for filing chart when determining I-485 eligibility. This is crucial information. Let me give you a practical example to illustrate how this works in real life. Consider Priya. Priya is a software engineer who came to the United States on an H-1B visa in 2015. Her employer filed her perm labor certification, and her I-140 immigrant worker petition was approved with a priority date of December 2012. She is chargeable to India. For years, Priya has watched the Visa Bulletin every month, hoping for movement in EB2 India. She has changed jobs using H-1B portability. She has had children who were born in the United States. Her oldest child is now 10 years old and has never seen her grandparents in India because Priya has been afraid to travel without advance parole, which she could not obtain without filing her I-485. With this April 2026 bulletin showing EB2 India final action date at January 15, 2014, Priya's priority date of December 2012 is now current. For the first time in over a decade of waiting, Priya can file her I-485 adjustment of status application. She can file for her employment authorization document. She can file for advance parole. She can finally take her children to meet their grandparents. This is what these numbers mean in human terms. This is why this matters. But here is the reality check. This movement is positive, but the system remains fundamentally backlogged. Congressional immigration reform that would meaningfully address visa backlogs has not occurred. The per-country caps established under the Immigration and Nationality Act continue to create disproportionate wait times for applicants from high-demand countries like India, China, Mexico, and the Philippines. Administrative actions and visa bulletin management can only do so much within the existing statutory framework. However, this protection and this progress may not be permanent if demand patterns shift, if annual visa numbers are consumed differently, or if future policy changes alter how visas are allocated. So what should you do right now? Let me give you a clear action plan. Step 1. Check your priority date against the April 2026 Visa Bulletin. You can find the official bulletin at travel.state.gov. Know exactly where you stand in both the final action dates chart and the dates for filing chart for your specific category and country of chargeability. Step 2. Confirm which chart USCIS is accepting for I-485 filing. As I mentioned, for April 2026, USCIS has authorized the dates for filing chart for both employment-based and family-based categories. Verify this directly on the USCIS website. Step 3. If you are newly eligible to file, gather your documentation immediately. This includes civil documents like birth certificates and marriage certificates, passport copies, photographs meeting USCIS specifications, medical examination results from a USCIS designated civil surgeon, evidence of lawful status maintenance, and any required forms and filing fees. Do not wait until the last week of April to begin this process. Step 4. Consult with a qualified immigration attorney. This is not optional advice. This is essential. An attorney can review your specific situation, identify any potential issues with your case, ensure your applications are complete and accurate, and advise you on strategy, especially if you are considering actions like downgrading categories or porting to new employers. Step 5. Be extremely cautious of immigration scams. When positive immigration news breaks, scammers become more active. They target hopeful applicants with promises of expedited processing, guaranteed approvals, or special connections inside USCIS. None of that is real. Only work with licensed attorneys or DOJ-accredited representatives. Verify credentials. Protect yourself. This could affect you even if you are not in these specific visa categories. Visa Bulletin movement has ripple effects across the entire immigration system. When employment-based categories move forward, it can affect H-1B dynamics, employer willingness to sponsor, and the overall competitive landscape for sponsored workers. When family-based categories move forward, it affects consular processing demand, USCIS workload distribution, and the timeline for related applications. Looking at the broader policy context, there are no pending legislative changes that would dramatically alter these categories in the immediate term. The per-country cap legislation that has been proposed in various forms for years remains stalled in Congress. Any comprehensive immigration reform would require passage through both the House of Representatives and the Senate, followed by presidential signature. Regulations implementing any new legislation would then need to be drafted, published for public comment, and finalized through the Administrative Procedure Act process. This means even if legislation were passed tomorrow, implementation would take months to years. The practical reality is that for the foreseeable future, the monthly Visa Bulletin remains your primary indicator of visa availability and filing eligibility. I want to take a moment to acknowledge what this process means for so many of you watching. Immigration status is not just a legal technicality. It affects your ability to stay with your family. It affects your employment stability and your ability to build a career without constant uncertainty. It affects your financial security and your ability to plan for the future, to buy a home, to invest in your community. It affects your long-term residency and your pathway to citizenship, to full participation in the American society you have contributed to, often for decades. I understand the emotional weight of checking the Visa Bulletin every month. I understand the disappointment when numbers do not move or when they move backward. And I understand the cautious hope when you see movement like what we are seeing in April 2026. Stay informed, stay prepared, stay hopeful, but grounded in realistic expectations. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. I want to hear from you. Drop a comment below telling me your visa category and your priority date. Let me know if this April 2026 bulletin affects your case. Share this video with anyone you know who is waiting for a green card, because this information could change their life. And if you found this breakdown valuable, hit that like button because it helps this channel reach more people in the immigration community who need factual, trustworthy analysis, not rumors and fear. Thank you for watching. Stay informed, stay prepared, and I will see you in the next update.